Well, good morning. Day 4. You're probably as excited about that as I am. For all the time that you've spent, I just hope that you're able to leave these proceedings with great satisfaction. Just a little about myself. When I graduated from Drake Law School, I joined a firm in Knoxville. There were 5 attorneys, and it was a general practice firm. So we did everything that our clients' legal needs required: civil, criminal, dissolution of marriage, estate work, probate, real estate transactions, and a lot of tax returns, farm tax returns, individual, small business. And that, we also consolidated the first and probably the only 2 cities in the state of Iowa that have ever been consolidated, Melcher and Dallas. There's been other cities that have added to themselves, but they've never consolidated. So that was exciting for a young lawyer to be a part of that. But the general practice and that background really gave me a good, solid legal foundation so that when I joined the Court of Appeals in 1996, I could really start in helping to manage that caseload and work on those opinions. I was looking back because I've been on the court almost 15 years, and that translates to about 1,500 decisions that I've authored, and then sat as a panel member on an additional 3,000 because we sit in panels of 3, so that we are then concurring or dissenting with our panel members on all those cases. As you probably know, the Court of Appeals does not appear in the Iowa Constitution. Well, except the fact that the Constitution says the General Assembly may from time to time create such inferior courts as it may choose or as are needed, and so we're the inferior court, and that's fine because we like that little bit of humility. But when the court was created in 1976, it was created with the function of being a pour-over court to the Supreme Court so that it could help ease the burden of the caseload that the Supreme Court was facing. 20 years after its creation, when I joined the Court of Appeals, the numbers were something like 800 decisions a year decided by the Court of Appeals and 400 by the Supreme Court. Fast forward to today, in the last 2 or 3 years, the numbers have been more in the nature of 100 plus for the Supreme Court to decide and 1,000 for the Court of Appeals to decide. So if you think about 35 years ago when the Court of Appeals was created, the numbers were first like this, and now they're like this. The result of that shift in numbers has been far fewer published cases and not as much of a development of the common law that practitioners and district judges tell us is needed in the state of Iowa. We work with the Bar Association and meet periodically to listen to them and say, what are the litigants asking you? What are your clients asking you of the appellate courts? And we always hear, you should publish more cases. And we try. We're really working on that. I've been privileged the last couple of years to be one of the 2 liaisons from our court to work with the Supreme Court in trying to just find ways to manage our caseload. And in fact, a couple of weeks ago, we met with the Supreme Court, and Justice Wiggins was there. And we had a great dialogue with some suggestions on how to handle the caseload and the publication needs of the bench and the bar. And at the end of the meeting, if I can quote you, Justice Wiggins said, "We ought to do this more often," because we really do have a good dialogue with the Supreme Court, and they've always been receptive to listening to us and to trying to work on managing this caseload. The Supreme Court, frankly, has far more strengths then it has weaknesses. But of course, you hear about the complaints or the weaknesses, and those are the things that people want to have addressed, because we're all here. All the courts throughout the state of Iowa are here to serve the public. Behind every case, at the district court and on appeal, there are real people waiting for answers and waiting for decisions. And if decisions are slow in coming out, these people's lives are on hold. Even an adverse decision is finality, and people can move on. So we continue to struggle with the time and the delay on appeal, but we hope we're making a little progress. The Supreme Court and the Court of Appeals share adjudicatory functions, handling cases on appeal. But we have quite different adjudicatory styles. When cases are transferred to us from the Supreme Court, we try very hard, if it's a non-oral case, to have it reviewed, researched, and decided within 2 or 3 months. If it's an oral argument case, then it takes a little longer simply because it has to fit into the oral argument schedule. But these are the things that are different between our two courts. Our writing styles are different. I tend to, and most of the judges on my court tend to write very concisely, with clarity, laying out the facts, laying out the appropriate law, showing the reasoning, and then going to a conclusion. In fact, if any of the judges on our court exceed 25 pages, we start to give them a hard time, because we really think that we have to get the decisions out and get them on their way. Having said that, I have great respect for the Supreme Court and how they choose to occasionally write quite long decisions, because particularly if there's going to be a shift in the law, or if the Supreme Court is going to take us in a different direction, they need to lay out the case law of where we've been, and then take a look at how that direction has changed and chart a course for the future. The one thing that I'd like to bring to the Supreme Court is my writing style, which is indicative of the Court of Appeals, to address the cases that perhaps don't need quite so much ink devoted to them. One way that I have been able to effectuate change in the past is when I was a trial attorney. I was terribly frustrated when I represented parents or children in child dependency cases. After a trial was over, it was very difficult to go out in the hallway and tell my clients, you know, you have a decision from the district bench, but it's going to take a year or maybe a year and a half to get an appellate decision. And they just looked at me with absolutely no comprehension of what that meant. So when I was appointed to the Court of Appeals, I thought, you know, maybe I could do something about that. And I gathered a task force of just very willing folks who were from all disciplines in the legal profession that could work with me to expedite appeals in termination of parental rights in child in need of assistance cases. I call it a task force, but there was more force than task because everybody was just such a willing participant. And when we gathered, well, before I even accepted them on the committee, I said, all right, this is not going to be a twice-a-year task force. You have to commit to meeting one day every month until we get this done. And they just said, of course we will. They were so excited and so enthusiastic. So we did that. We met for 9 months, and at the end of that time, we had drafted rules of expedited appellate procedure, a statutory change, and forms so that attorneys who utilize the expedited procedure could have an easy path. The result is, in 2002, all of this was enacted and adopted, and right now we have an expedited appellate form that just rockets past the traditional appellate procedure. And to that end, the children and the families in Iowa who are caught up in the juvenile system have permanency and finality much sooner than they did 10 years ago. Those are the types of qualities that I would hope to bring to the Supreme Court, and I would assume and know from working with the Supreme Court in the past that they would be receptive to new ideas just as a way of serving the public and managing the appellate caseload. And I welcome your questions.
Thank you very much, Judge Vogel. Why don't we start with Mr. Fitzgibbon's side of the table? I'm going to call it Ms. Walker's side of the table today.
Good morning, Judge.
Good morning.
Thank you for being here, and thank you for showing interest in this very important position. We've looked through a very qualified list of many good applicants, and one concern that I think is shared by many is the lack of women on our Iowa Supreme Court. I'd like to know your thoughts in that respect. I know that it would be a disservice to you and to many to just suggest that someone be appointed because they are a woman. Mm-hmm. But I'm wondering if we get to the point, and we have a lot of qualified people, if we get to the point where all things being equal, should the fact that we need a woman on the Supreme Court be a factor tilting in the favor of a woman?
Well, the task of this commission is to nominate the 9 most qualified people. But as you said, Mr. Fitzgibbons, all things being equal, that can be a consideration. But I firmly believe that gender should never trump competence.
Mr. Pace.
Thank you, Justice Wiggins. Good morning, Judge. You have spoken to this already a little bit, but if you could maybe elaborate some more on how the Court of Appeals and the Supreme Court work together now, particularly in light of the further review procedure. And for those of us that aren't on one of those appellate courts, we've heard various things about how that works, whether it works well or not. Do you have some thoughts about how that could be perhaps streamlined or some improved?
Well, I believe that you take about 5% of our...
You're looking at me.
I am. I believe you take about 5% of our cases for further review.
We review about 400. Last year there was 451 further reviews. The year before it was 501.
Right. We'd really like if you would just send them back with gold stars and say, well done, well done, well done.
More often than not, we do say well done.
I know. You're very gracious about that. We do have one new technique that I don't think I'm speaking out of school, that when the Supreme Court sees one of our cases on further review that they acknowledge addresses a new fact pattern or an area of the law that we really don't have much law established in the state of Iowa, then they will ask us to publish that decision. So there is a lot of benefit on the further review, and I think the Supreme Court's done a fairly good job of timely reviewing those applications for further review.
Every night. Any other questions? Ms. Walker.
Thank you, Judge Vogel. My question relates to the juvenile court issue, and I agree with you that it needs to be expedited. I guess I do quite a bit of juvenile stuff, and from the parents' perspective, it could probably be done in about a week because none of them get overturned. And so I guess my question, can you explain to me how I can reassure parents that they are getting a fair review when it comes up? Because when you go to look for case law in support of that, there's pretty much none.
Are you speaking about from the trial court?
From the termination perspective, when your client's rights have been terminated and you go to try to appeal and there's a paragraph on the petition for appeal that asks for supporting law,
right?
It's next to impossible to find any because they all get affirmed. So I guess, how do I explain to my client that once their rights have been terminated, their appeal is actually being considered and not just affirmed?
I'm sorry if that's the impression, because they are being reviewed. We have not only had the culture of circulating the proposed decision to the panel, but to the full court. And that way, all 9 judges can open it up and see how the fact pattern and what has been done in that case represented the needs of both the children and the parents. But as you know, oftentimes juvenile cases are not a single incident. They're a moving target because there has been abuse or neglect over the course of perhaps a year or two. So we really think that the district court does a wonderful job in its task of finding clear and convincing evidence or not. And occasionally we do reverse when there hasn't been the statutory proof that is required. But we do find that the expedited appeals do not prejudice any party, because when the trial is over, the record is closed. So even if the parents would make a stellar turnaround, that's not for our review because it isn't before us. So the expedited appellate process really just enhances the wait time. It rockets past it, I should say. It doesn't actually prejudice any of the parties.
Any questions from the other side? Mr. Cook?
I have.
Oh, I'm sorry, Tim. I told you I'm far side.
Morning, Judge Vogel. Mr. Pace caught most of my question, but I wanted to let you know that this is the final day, and some of us feel we've been on camera so much. I kind of feel like Regis up here now. So.
Make me Kathy Lee?
Yeah, whoever it is. I see. Do you have some family here you'd like to introduce?
Well, I have my husband,
Okay.
and it seems like my daughters, but it's actually my law clerk and my
Okay.
shared staff attorney. They're just
Good.
fabulous.
Good,
They
that's
they
fine.
make me look good.
Yeah, we can go on down.
I'm sort of jealous. You have 2 people helping you. Mr. Cook?
Thank you, Justice Wiggins, and Judge Vogel, thank you for applying for this important position. I, too, share the same view and concern that Mr. Fitzgibbons has about the lack of women on our high court. But I wanted to ask you about something else, and it's a follow-up on your comments about the length of opinions. It sort of reminds me of the old Mark Twain quote that I'd have given a shorter speech if I had more time to prepare. What is it about the length of opinions that concerns you, and why do you think there should be shorter opinions on the Supreme Court?
Well, I have to speak from the Court of Appeals perspective in that we really strive to get an answer out. We sometimes have to do some pretty in-depth analysis because there isn't a lot of case law to apply to the fact pattern that we get. But we nonetheless try to get that out to show direction not only to these litigants, but to show future litigants that may have a similar situation. The justices on the Supreme Court all have different writing styles. Some of them are longer than others. And I think my hope is that when a lengthy decision is filed, that nonetheless the district bench and the bar can follow the decision so that they have something to work with. I had a district court judge come up to me in the Dickinson County Courthouse and say, "Did you read the opinion? I tried to get through it. I couldn't get all the way through it. What did it hold?" And I had read it because it was one of mine on further review. And it's just a matter of making sure that the message gets out and it isn't lost in the eloquence of the decision. And I think the strength of most of the Supreme Court decisions is that in the opening paragraph or two, you really understand where they're going. It's like a summary at the beginning of the decision, and that's to their benefit.
Thank you.
Ms. Skogerson?
Thank you. Judge Vogel, we really appreciate your application, and thank you for being here today. I just wanted to ask, do you play well with others? I would like to hear a little bit about the collegiality on the Court of Appeals and how you think working with those colleagues might also transfer to working on the Supreme Court.
Thank you. The Court of Appeals is a wonderful working environment. We have great collegiality, and we don't hesitate to disagree with each other, but we do it in a very friendly sense. I've never noticed in 15 years, I've never noticed negativity. It's just a difference of opinion, and not afraid to put it down in a dissent, and then move on and maybe go out to dinner together. It's that kind of atmosphere that's been wonderful. On the Supreme Court, although I haven't served with Justice Wiggins or Justice Apple, I have served with both Justice Cady and Justice Hecht on the Court of Appeals. And again, we oftentimes disagreed, but we got along just fine. I mean, we're Iowans, and we know how to behave, and we know how to be collegial with each other, even in the face of disagreement. And I see my red light is on.
No.
Oh, yes.
That may save you when you're up there.
Okay.
Any other questions? Mrs. Redenbaugh.
Thank you, Judge, for being here. I've been trying to be careful about how I'm drafting this question, and it builds on what Amy has asked. And I want it to be that we're speaking in generalities, not about the women in the candidates in this pool. But some of our questions in this process have addressed the barriers of women getting advanced in their professions. And I wonder if you want to, maybe you don't, want to address for a few minutes whether you think things like collegiality for women, do you think they're judged fairly when it comes to their personalities and collegiality issues in those advancements?
Well, I think people are people, and every man and every woman has a different personality. So I think there are some that are easier to work with than others. But I've always had really good relationships with the women, both on my court and with the staff. I feel an obligation to be a mentor to young attorneys that work for us. And I hope that I've been able to be a good role model. When I started in Knoxville, I was with 4 men in the law firm, and they just treated me so well, so nicely. And in fact, when I interviewed, I had 2 small children, and I was pregnant with my 3rd, and they still hired me. So I just think that you can mentor young women, and you can be a role model, but you can also just be yourself, be a good attorney, and be a good judge, and get along with folks.
Thank you.
Any other questions down this way? Well, I guess the red light does save you. And we thank you very much for your time and wish you the best of luck.
Thank you all. Thank you.